Court is calling 2025 CR 0000615, State versus Joseph Matthew Juarez for the defense.
Victoria Cruz on behalf of Raymond Martinez.
And are you Joseph Matthew Juarez?
Yes, Your Honor.
Do you have any objection to this attorney standing in for Mr. Martinez?
No, Your Honor.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Joseph Matthew Juarez,
All right, you may proceed.
Thank you, Your Honor. Mr. Juarez, how old are you?
23.
Are you currently employed?
Yes.
What are you currently employed as?
Nolato as an MQT inspector. No, just an MQT.
Okay, and how many hours do you work a week?
I believe it's a solid 40 now.
Okay, and how much do you make an hour?
I think it went up to either 18.25 or 17.05.
Okay, and do you have any money in the bank at this time?
$20 in the bank at this age.
Okay, do you have any other sources of income?
No.
Do you rent or own any property?
No.
Who do you currently live with?
Mom.
Do you pay any bills?
Yes.
What bills do you pay?
Water, phones.
How much is that?
125 for the phones, and depending on water, it can vary from 125 if I have a month payment to 85.
Okay, do you have any jewelry or assets that you could sell?
No, Your Honor.
No, okay, do you have any family members that could provide any additional monies other than what they provided to retain your counsel?
No.
Do you have any banks that could loan you any money that you know of?
Not to my knowledge.
Okay, Your Honor, that's about all I have.
All right, so counsel, with regards to
Boom. The judge just shut down the defense's request for expert funds. In a high-stakes case, experts, like forensic accountants or medical witnesses, are critical. By finding the defendant, Mr. Juarez, unable to retain any type of experts, the court acknowledges his indigency. This is a massive resource hurdle for the defense right out of the gate. His ability to fight this case just got seriously limited.
to the request for the experts, the court is going to find that the defendant is unable to retain any type of experts in this case. We can go off the record, Cindy, but what I need is there's no expected price or,
Oh, you need
Yeah.
the amounts?
yes,
Okay.
just an approximate. The approximate, then I'll review it, and he doesn't need to be present for that.
Absolutely.
All right.
Thank you so much.
All right, you're
May
welcome.
we be excused and we keep our dates?
Yes, keep your dates, but please come back. We'll be here tomorrow. So if you want to come back tomorrow with an approximate of price, then I will sign it.
Absolutely. Thank you, Your Honor.
All right, thank
May we
you.
be
Thank you.
excused?
Yes, have a good day.
You're good to go.
Roberto Ambrosino, who are you here for?
Good morning, Judge. I'm here for Cassandra Oberlender. I believe she's in the Zoom waiting room for a restitution hearing. She lives in Colorado.
All right, state on Cassandra Oberlender. It's for a restitution hearing. Are you all prepared to proceed?
Yes, sir.
All right, Cassandra Oberlender. And do you all, first of all, do you all have a restitution amount?
We have a witness here, Judge.
Oh, okay. Court is calling 2024 CR 012530, State versus Cassandra Oberlender. Can I have parties announced for the record?
Lauren Espinoza for the state.
For the defense?
Roberto Ambrosino.
And are you Cassandra Oberlender?
Yes, ma'am.
All right, any objections to Miss Oberlender appearing by Zoom?
None for the state, Your Honor.
And defense, I'm assuming you have no objection to your client appearing by Zoom?
No, Your Honor.
And Miss Oberlander, you do realize that if you wish to appear in person for this hearing, you can appear in person. Do you understand?
Yes, ma'am.
All right. So do you consent to having this hearing by Zoom?
Yes, ma'am.
All right. State, do you have any witnesses?
Yes, Your Honor. State Code Aida Ramos.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yep.
All right, you can lower your hand. Make sure you keep your voice up for the court reporter to hear and for the persons on Zoom to hear. If you'll state your name for the record.
Aida Ramos.
All right, state, you may proceed.
Ms. Ramos, what is your occupation? I'm a realtor, property manager.
Your property manager for which property? Simple Realty Services. Is Simple Realty Services renting to or were they renting to a tenant, by by the name of Miss Oberlander? No, that was her boyfriend. What is her boyfriend's name? Riley?
Okay, so guys, I'm so sorry. You are gonna have to speak up because I'm having trouble hearing. And the court reporter, I'm looking at her real time and she's having problems hearing. All right, so if you'll repeat your last question, please.
Yes, what was Miss Oberlander's boyfriend's name?
Riley.
And was Riley a tenant with the property?
Yes, ma'am.
What property did he reside at?
1238 Old Lake Drive.
Was there an incident involving Mr. Riley and the property, or I'm sorry, Miss Oberlander and the property?
Yes, ma'am.
What incident was that?
She burglarized.
Was there
She broke
damage?
in.
She broke in to which property again?
1238 Old Lake Drive.
What damage was caused, if any?
Well, she broke in and she broke the door of the garage and went in, and I have the video where, because we had cameras inside, and she went in there and she also stole money. That I also have where her boyfriend Riley texted me, and she said that he could-
Objection, hearsay.
Sustained.
So you said she broke in through the garage, is that correct?
Yeah, the garage.
Did you have the garage fixed or replaced?
Yes, ma'am. I do have for the invoice here. I'm sorry.
Did you get an estimate done for that repair?
Yes, we did.
Through which company?
Alpine Property Group.
And how did that happen?
Well, after we made the report, you know, I did speak to the owner and he requested for us to. have-
Objection, hearsay.
All right, so just talk about what, may I ask a question? Any objection?
No.
Any
No
objection?
This is a restitution hearing for an alleged burglary, and the property manager is on the stand. But listen to this cross-examination. The defense attorney immediately starts chipping away at the evidence. The property manager didn't pay for the repairs, and their knowledge is secondhand information. This is the defense attacking the foundation of the restitution request. If the witness can't verify the costs, how can the court legally order the defendant to pay for them? The $850 door is hanging by a thread.
No.
All right, so what damages are you alleging was caused by Miss Oberlander?
The broken of the door of the garage.
Okay,
and
the garage door, what else?
Camera.
And the camera.
Mhm.
What's the price to repair the garage door?
Like here, it was $850 for the door and the installation, and the security system was $650.
All right, so how much for the garage door?
$850.
$850. Does that include the price of the door
And
and the installation?
Correct.
And how much for the camera?
It was $650.
$650. State, any other questions? Defense, any questions?
Yes. Isn't it true that Riley, the actual tenant to the property, had a key to access the room where the camera was?
No, not that, no. Only to his room. There was an attachment there where he actually lived. The door where she broke in, it was on the other side.
So in what manner are you saying that he broke the door or that she broke the door?
She broke in. Well, I don't know what she did because the camera was inside the garage, because we had cameras inside the garage.
Isn't it true that she was given, or I'm sorry, that Riley was given a key by someone named Sergio that actually allowed him to have access, even dispute over whether he was supposed to be entering into that property?
No, he only had the key for his area where he lived.
When did you repair the property after that?
The date here of the invoice is for June the 1st.
June the 1st of 2025?
2024.
Okay. This incident actually happened several months before that, isn't that correct?
Well, the incident happened. It happened, well, we repaired it after the break-in.
Right, but I mean, you allegedly let the house go unrepaired then for several months.
Well, this is where I have the invoice. I got it from the owner,
Okay, why isn't the owner here today to testify?
because I'm the property manager.
Okay, so you didn't actually pay to have any of this fixed?
I didn't pay for it. It was the owner, the company, which is Simple Realty Services.
Okay, and so you don't know anything that wasn't secondhand information that was told to you by somebody else?
No, sir.
Okay, pass witness.
All right, any other questions?
I think we'll state your honor.
Defense, any other questions?
No.
No, Your Honor.
All right, thank you. State, any other witnesses?
No.
All right, oh, I'm sorry, you may have a seat. Defense argument?
Judge, my client contends that there was a key to enter the property. Basically, this was a room that he was renting and he had access to the whole property. And that she, yes, did go into that particular room without consent. And she did damage the camera. So we do not contest that amount, but we do contest the amount that's being alleged with regard to entering the room that the camera was in. She basically states that she would have had access to it.
All right, state. So the defense is stating that they have no objections to the amount of the camera, which is $650.
Courtroom chess. The defense concedes the $650 for the camera but fights the $850 for the door. This is a classic legal tactic. Show you're reasonable by admitting a small part of the claim while aggressively challenging the larger, weaker part. The judge's decision to order the full $1,500 based on the burglary of a building is a win for the state, but the defense forced them to fight for it.
So the court is ordering the $650 restitution because the defense does not dispute that. Would you like to speak to the door for $850?
Your Honor, this offense is for the burglary of a building, which was through the garage. Because there was the camera on the interior, we did not see the exterior entry. However, despite them arguing this key was given by somebody else, this damage was caused. We would urge the court to order this restitution because the damage was done to the garage.
All right. So this is what the court is going to do. What is the owner's name of the property?
Either Ramos?
All right, the court is, in this case, the court is ordering that restitution be paid in the amount of $1,500 for the price of the garage door and the price of the camera. All right, is there anything else?
Judge, can I get the name of the, where that's being paid to?
State, if you'll give her the name of the property owner, please. All right, thank you, counsel.
Thank you, Your Honor.
Eduardo Rodriguez. All right. So on this case,
So I conferred with Mr. Garahan this morning. There was a previous offer by a previous prosecutor that has been modified. I believe the client is very interested in accepting it. So what I'd like to do is, can we do a real short comeback to do an actual plea
tomorrow.
tomorrow? How busy is the court tomorrow?
Oh, we're going to do closing arguments in the morning. Oh, I'm sorry. All right, Vashawn is like, no. All right, we can do it today.
The problem with that is it's going to be very difficult for me to do it today schedule wise because I have a massive day lined up. I came here first. But we have an agreement, Judge.
Are you available in the afternoon?
Good news. I don't know. I would have to check on that.
Let's see if you're available to do it in the afternoon and see if the state can start the paperwork.
Okay.
All right, thank you.
What do you want him to do? Sorry.
He can come back this afternoon at 1:30.
That's it. It's not gonna work.
I'm sorry, not at 1:30, at 1. All right, DeMonte Williams. Right, so I know he has some unindicted cases.
That's the issue, Judge, and I confer with Mr. Garahan. We've reached out to the intake prosecutor that's been assigned, just trying to figure out what's gonna happen. Is it gonna get indicted? Is it not?
Do they know when they will have?
But we just did that this morning, Judge.
All right, Norma, if I can have a 30-day reset on this. All right, September 22nd. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Just have a seat and your attorney will bring the form to you.
Thank you, Judge.
All right, thank you. All right, Enrique Soriano. Hello. How's it going?
It's going pretty well. Just administratively, the reason I got into approach was, I guess for one, was a reset. But the first thing is that Mr. Soriano is now indicted as a first degree felon.
Yes.
Additionally, there's an additional case that's a first degree. I'm not on the first degree list. Ron Ross was either appointed by the court or by MAC to handle the additional first degree. The case that I was originally appointed to began as a third degree. It's now been indicted as a first degree.
Okay.
I'm not on that list. I wanted to bring that to the court's attention to see how she wanted to proceed.
All right, Miss Ferguson. I guess since Ron Ross, he should be here today, right?
Which case is he on?
Soriano on page 10 on all cases. So Adam, where have you been? Where have you been? Enjoying life?
I do have a flight today to about
Oh, where are you heading?
out of state.
Okay, well, enjoy. I hope it's for something that's fun and not work.
I'll send you a text
Okay,
so that it's not aired everywhere.
okay.
All listed on the PF case. And
Oh.
then the two indicted case have Adams.
All right, so Norma, if you can put Ross on all of the cases, please. All right, so we'll put him on all of the cases, and what we'll do is we'll reset your case for 30 days. That'll give him a chance to look at these charges as well, okay?
Okay, Judge.
All right, do you have any questions about anything?
I am aware that I have court on the 27th still. Am I still going to appear for that one or?
That
Is
should
there-
be the PF case.
All right, that PF case is not, Norma, is that PF case going to be set here?
He said in,
Yeah, so that's with Judge Nahara, because that's where they send the PF cases. But I'll set you here in 30 days and maybe they'll just move it here. What date, Ms. Ferguson? All right, so we'll be back on September 22nd in this court. And then your attorney, Ross, he'll get notice that he's been placed on these cases as well. All right, you're welcome. Counsel, is there anything else?
I'll submit my voucher. Thank you, Your Honor.
All right, thank you. All right, have a good day.
Hey, excuse.
Yes, thank you. All right, Anthony Jacob Herrera. Good morning. Hey, they're going paperless. We're gonna see what happens when the system crashes, because
prefer paper.
thank you. Thank you. So that's why we have to do it this way now, because I don't have any files. All right. So on this case, has the state tendered an offer?
Yes and no. So last time we were here, I was talking to Ms. Galloway about it. I texted her this weekend. I didn't know she was on vacation.
Yes.
So she was telling me that we're still waiting. I don't know if the court remembers that we were waiting on information from the feds.
Yes.
So that we're still waiting.
Okay.
I know that she sent the TUI letter, I believe. So
Mhm.
that's actually what we're waiting on.
All right, Ms. Ferguson. All right, this is gonna be the last reset to see what
fine.
they're gonna do. Norma, give them a 45-day reset, please.
yes, ma'am.
Thank you.
You're welcome. Let me get a date. Yeah.
So we just signed for.
Mhm.
I can do October 6th.
All right, October 6th, council.
Check the original trials. There might be, if anything, I'll let Norma know 2 weeks before.
I always wonder, do the piercings in the face, does that hurt?
It's exactly as it is.
No, it is, okay. That's why I only stopped at 2. When they got to the third one, I was like, yeah, that's getting extremely painful. Thank you for dressing appropriately for court. Just have a seat. Your attorney will bring the reset form to you. Once you sign that, your excuse.
Okay, thank you.
You're welcome. John Henry Moore. Hello, Mr. Moore.
Hello.
How are you doing?
All right.
Counsel, where are we on discovery?
I have just about I have everything. My problem is I need to take a hard drive up there to get the stuff that won't fit. I'll do that by tomorrow.
All right. And
Everything else is ordered and I received it.
okay, and there are no other issues with competency or anything?
No, ma'am.
All right, was the state able to tender an offer?
They were, Your Honor, and for the time being, my client has rejected it. They will keep it open for 30 days. And I'm gonna continue to work with him, talk with him, and or the court's next step.
All right,
So-
thank you. All right, is there any other thing, state?
No, I think everything's been disclosed. I think he
Yeah.
just wants time to discuss the offer. It's fine.
All right, thank you. Ms. Ferguson, if I could have a 30-day reset for a plea deadline date? 30-day reset for a plea. All right, it will be September 23rd. We'll bring you back on September 23rd. If your attorney wants you brought back sooner, he'll let us know and we'll place you on the docket sooner. All right, this is just to give your attorney time to look over all of the evidence and to talk with you, all right? All right, thank you. Have a good day.
What? Did we say? Hey, yeah, my clipboard. I apologize, Your Honor. I'll be more careful in the.
All right, thank you. Valerie Marino. Good morning. Thank you for dressing appropriately for court. Yeah, yeah. All right, so where are we on discovery?
Judge, I think we have everything. It's a pretty straightforward case. We just, this is our first appearance. I did talk to the prosecutor. We got an offer, so we just kind of need to see how they mesh up.
All right. So I'll recall you back in 30 days. That will be your plea deadline date. At that time, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not reached the agreement, then your next setting is going to be a trial date. You understand? All right. What date, Ms. Ferguson? All right. So just have a seat. Your attorney will bring the reset form to you. Once you sign that, you're excused.
Okay.
Thank you. Thank you. Roman Villarreal.
Morning, Judge.
Good morning. How are you doing?
Okay, thank you. What's that?
Oh, that's we're having a trial, and so different news organizations come in to watch it.
Got you.
Yes. Hi, thank you for dressing appropriately for court. All right, so where are we on discovery?
I have out of discovery now. Just I'm gonna get a fee offer from the state and we can have 30 days.
All right, has an offer been tendered?
About right.
She's in the
Okay.
process, Johnny, but I'm gonna wait for that.
All right. So Ms. Ferguson, need a 30-day reset for a plea deadline date? All right, so we're going to bring you back on September 22nd. That will be your plea deadline date. Once you sign the reset form, you're excused. Just have a seat and your attorney will bring the reset form to you. Okay, thank you. All right, could I have the parties on Amber Marino? Hello. Oh, thank you for dressing appropriately for court. All right, the court is calling 2025 CR 006931, State versus Amber Marino. Can I have parties announced?
Lauren Espinoza for the state.
And are you Miss Marino?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Marino, did you review the application for deferred adjudication with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, are you waiving the reading of the indictment?
Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Marino, did you review court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Moreno, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be $1,000 fine probated. The state is recommending deferred adjudication. There's to be restitution to the complainant in the amount of $1,764.08. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Your Honor, can it just be noted that this restitution has to be split amongst 3 co-defendants, so I guess joint and several liability for that restitution amount?
All right. So here's the thing with that, and I think your attorney probably explained it to you. If there are other people who are part of this, all of you owe that amount.
Yeah.
If for some reason, if it's involving let's say it's involving a total of 3 people, I don't know how many people that are alleged. If 2 people decide they're not paying it, then you have to pay the entire amount. Do you understand?
Yes.
So I know that sometimes when people enter pleas, they, in their mind, they'll say, oh, let me divide this restitution amount among 3 people, and then I only owe that amount. Do you understand?
Mhm.
Now, if the other parties are paying their sum, the person that's owed this money, they're not going to be able to get $1,764.08 from everyone. It's just, that's the total amount. Do you understand?
Yes.
All right. Does that clear everything up, State?
Yes.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yeah.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, state offers what has been marked as State's Exhibit 1.
No objections, Your Honor.
All right, and state, you may be excused. You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Yeah, we spent a lot of time yesterday, going over everything, and she's agreed to accept responsibility. At time we plead guilty, and I suggested to her to plead guilty, because she is guilty, rather than try to hide behind a no contest plea. So that really demonstrates an acceptance of responsibility. A situation where she was just overwhelmed by what was going on in her life, and something snapped yesterday. I really characterize this as average behavior. She's never been in trouble before, 22 years old. So we've asked the court to give her a chance on deferred and follow the plea agreement.
Okay, you say she's 22? All right. So let me ask you, who is Roman Villarreal to you?
That's my boyfriend.
All right. And your relationship to Valerie Marino?
That's my sister.
All right. And how old is your child?
She's 3.
3? All right. So let me explain something. And this is what I would always tell my clients who are on the CPS side, right? When people have a child together, That's the person you chose to have a child with, right? It's very important that you're able to co-parent, because even though you're no longer with that father and maybe you've moved on with someone else, your child still needs to see what healthy relationships are. And I know your attorney is saying this is out of character, but if you can just internalize and think about how your child was feeling with all these adults, these grown people just screaming. And this is what I've learned. And you've done family violence cases. This is what I'm sure your attorney has probably told you. If he hasn't, I'm going to tell you. During child exchanges, unless this is like a Hallmark movie, don't bring your significant other with you for a child exchange. I have never seen that work out well. So by the same token, if the father of your child is coming to pick up his child, he shouldn't be bringing his girlfriend with him. And if you're going to pick up your child, you shouldn't be bringing your boyfriend or new husband or whoever it is with you, because tensions just rise. And if there's an issue where people are concerned about their safety during custody exchanges, that's when you say we're going to meet at a substation or meet at the police. You understand? But from reading everything, I see that there were issues going on and maybe the child needed help and all of these other health issues going on. So the $1,000, how much are you able to pay per month towards that? And here's the thing, give me a reasonable number, because sometimes people think I want to hear, oh, I'll be able to have $1,000 in 20 days. If that's not you, that's not you. It's just that I'm going to be placing you on deferred adjudication. I'm going to grant your application, but you're going to need to be able to let the state know, and I'm sorry, the probation officer know how much reasonably you can pay a month, because this has to be paid off. And since one person is your sister, the other one is your boyfriend, you know, usually your mother will say, hey, you better help your sister pay this off. So reasonably, what do you think you can pay per month towards this amount?
I can do 100.
Okay. All right. And was CPS involved at all?
No, Judge.
All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. Are you employed?
No.
All right. So how are you supporting yourself?
Well, I'm getting child support, and
Mhm.
my boyfriend would be the one to financially.
Okay. Here's the thing that, you know, as a side note, you never know if a boyfriend is going to be around for the long haul. You never know if somebody has a girlfriend, if they're going to be around for the long haul. So you need to be able to say, because you have a child, you need to be able to say, you know what? If he were to leave, how am I going to support myself? Will I be able to provide a roof over the head for me and my child? You understand?
Yeah.
So you have to calculate that. All right. In this court, I require that people have employment. All right. So there's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be restitution of $1,764.08 to the complainant. Are you all able to do child exchanges at a location different from this location?
She'll have to answer that, Judge. I don't know how she's doing that now.
We're doing exchanges at the police station on Sassamon.
Okay. All right. So for now, you can't have contact with that specific address. State and the complainants don't want her back at the address, correct? All right. So you can't have any contact at that address. If there's an emergency that comes up with your child and it's at that address, then you'll probably have to call the police or somebody for a welfare check. Your attorney will let you know what to do in that situation. Okay.
Okay.
So there's to be no contact with the location. And at some point, if things go well, the complainants may decide that it's okay for you to have contact at that location. All right, there's 100 hours of community service restitution. I'm going to order anger management. Once you've completed anger management, 50 of those hours will be deemed satisfied. And the remaining 50 hours will be satisfied once you've completed parenting classes, and I'm gonna order parenting classes. Field visits one time per month for 3 months. And there's $1,000 fine, and that will be probated. And restitution is to be paid at $100 per month. Probation, is there anything else? No, there wasn't a request for a no contact with him, just the address.
I have one more thing, Judge.
Yes.
What would you set the supervisory fees at? Set them at the minimum because of.
In regards to that, legally, now that they've changed things, she'll have to fill out a form. And once she fills out that form saying that she's indigent and provides proof, I'll receive notice of that, and then I'll be able to make a decision on that.
And can she get that form from probation to fill out?
Yes.
Okay.
All right. And what I can tell you, supervisory fees, they help probation run their operations. Okay.
Okay.
All right. Is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
All right, we can go off the record. Here's the thing: to be successful on probation in this court, communication is key. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court and address it with me. Do you understand?
Yes.
All right, good luck to you. Make better decisions, okay?
Thank you.
All right, you're welcome. Thank you, counsel. All right, Jose Ramon Alvarez, come forward. Good morning.
Good morning.
Thank you for dressing appropriately for court.
Thank you.
It's my understanding that you're asking for time to retain an attorney.
Yes, ma'am. I'm working on the fees and I should be expecting 2 checks these next 2 weeks. So I'll be able to get to the time.
All right, so when will you be able to have an attorney?
Within 2 weeks.
Within 2 weeks?
Yes, ma'am.
All right, I'm going to give you 30 days, okay?
I appreciate it.
All right, Ms. Ferguson, if I can have a 30-day reset on Alvarez. All right, so on September 22nd, you need to have your attorney here, okay?
Yes, ma'am.
If for some reason you can't afford to hire an attorney, you can fill out the data information sheet to see if you qualify for an appointed counsel.
Where do I find that sheet at?
They have it here. No.
Okay.
You need to have to sign the reset form.
Yes, ma'am.
All right. All right, Pearl Gonzalez.
So with regard to Ms. Gonzalez, Judge, I know that she already has an active warrant for she didn't come into court on her compliance hearing date on July 29th. No, she had a PR personal bond, so I did contact pretrial services to see if they have any updated information, Judge, but to no avail. But they would contact me if they get some information.
Okay, as soon as you have information and she makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. Adriana Ramos. All right, so where are we on discovery?
Yeah, it's Judge, so I was just assigned the last setting, which was sometime in late July. I believe I've got all the discovery. I've reviewed quite a bit of it. I've conferred with my client, and I believe at this time there was an offer in the file, and she's not going to be taking that off.
All right. So are you asking for a jury trial?
Yes, ma'am.
Okay, yeah. So here's the thing. I can give you a jury trial or either a bench trial. A bench trial means you come before me and I would hear the state's witnesses. What I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they're unable to prove their case beyond a reasonable doubt, I'm going to find you not guilty. With a jury trial, that's 12 people, citizens from Bexar County. They'll sit, the state will present their evidence, and then they'll be the ones who make a decision if they can come to this decision. So do you want a jury trial or a bench trial?
I would,
If you want to.
We haven't really spoken to her about that, Judge, but I mean, my advice is gonna be that we take a jury trial.
Okay. All right. How long do you expect this trial to last?
3 days, Judge.
All right. Ms. Ferguson, I need a jury trial date for family violence. It's going to be 3 days, excluding jury selection.
3 days?
3, I'm sorry, 3 including jury selection. All right, once you sign the reset form, you are excused. That's your jury trial date. Counsel, I need an acknowledgement of discovery sign. Yes.
I decided to change.
Well, we can talk
So,
about this.
yes, it's probably best that you speak to your attorney about that, okay?
So
All right, thank you. All right, Marcus Freeman. On this case, do you have all of the discovery, the dash cam, the body cams?
I have additional videos, but I believe there may be some additional information that I may be seeking.
All right, what additional information?
We filed motions. I believe there's a CI involved in this case.
All right, who's the prosecutor?
I've spoken with Mr. Garahan.
All right. Jason, on this case, he said he's gonna file a motion for discovery of CI.
Okay.
So when would you be ready to address that motion?
I just found that out just now.
Yeah, yeah.
So, I just would have to contact the detective judge.
Okay.
Next week or a couple weeks or.
All right.
Whatever you'd like.
So, Ms. Ferguson, on this case, recall it in 30 days, and counsel, you need to have whatever motion filed before then, so that the state can have notice. All right, September 22nd. Yes.
I was just told by my counsel that they picked the case, they threw the misdemeanor on.
Okay, so
I
here's,
never said that. Judge.
so here's the thing. You'll need to speak to your attorney about those things because he's your counsel. And sometimes attorneys, there are certain things they don't want me to know about. No, he's your attorney. So here's the thing. When you have conversations with your attorney, that's confidential. If you break the confidentiality, then that means everybody knows what's said, and maybe your attorney doesn't want that. So what's going to happen, your attorney is going to file a motion, and we're going to have a hearing, and we're going to have that hearing on September 22nd. Okay? All right, thank you.
Thank you, Judge.
David Escobedo.
Mr. Escobedo.
All right, so here's my question. On this case, is there a violation report?
There was a violation report. It was set for Monday, but because we were set today, Ms. Ferguson set it also the compliance hearing for today.
All right, do y'all have a violation report, and have you conferred with the state on the violation report?
I have not. It was for a calibration issue, which he has since remedied. I think he was supposed to be going on Friday.
All right, just one second. All right, sir, just have a seat. And defense, if you can confer with the state on that violation report,
Yes,
please. Rogelio Ibarra. Hello.
Good morning.
Good morning. You're very young to be in here. Yeah. All right, so on this case, where are we on discovery?
Judge, I believe that
Everyone, please whisper.
I need to have the lab discovery. And so we're filing a motion this morning to gather that. We do have toxicology report and it's pre-convened. So I need to go through that and probably have some assistance in reviewing it.
Okay. And how long do you anticipate that taking?
I don't know how long I know blood labs take typically 30 to 60 days, but yeah, I'm not sure as to how quickly the lab on the THC cases would take.
I don't know that. Ms. Ferguson,
Yes, ma'am.
on this case, he's scheduled for jury trial on October 21st. Could we just put this on October 21st for discovery? It has to do with labs and there's some backlog going on. Yeah, on Rogelio Ibarra, if you'll put that down as a discovery for October 21st. And counsel, whatever motions you need filed, they'll need to be filed before then.
Yes, Judge.
All right, thank you. Darlene Gonzalez. Court is calling 2025 CR 007801, State versus Darlene Gonzalez. Can I have parties announced for the record? State.
Honor, good morning. Frankie Sandoval on behalf of Ms. Gonzalez.
And are you Ms. Gonzalez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Are there any applications in this case?
Your Honor, you know what, there's an application for deferred, which I do not believe may be part of what's presented to the court. We may present that after we do the plea.
All right. And is it an application for deferred?
Yes, Your Honor.
Okay. Ms. Gonzalez, do you want the court to consider an application for deferred adjudication in this case? All right. Have you reviewed the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes,
If
ma'am.
you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She is, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There are not, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers States Exhibit 1 and all attachments.
No objection, Judge.
State, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Your Honor, in the interest of justice, we would ask.
Anything you wish to say on behalf of your client?
Your Honor, Ms. Gonzalez presents herself here accepting responsibility and just wanting to start the process of putting this behind her.
All right, who is Kenneth Ray Jackson?
Kenneth Ray Jackson is a friend of mine.
All right, not your boyfriend?
No, he's not my boyfriend.
You don't have any children together?
No,
You don't live together?
no,
Do you have any children?
no, I don't.
All right, who do you live with?
Me, I live with my mom.
And when's the last time you had employment?
A year maybe. About a
Okay.
year.
Why?
Honestly, I don't have a reason really. It's I helped my mom connect. She's sick. She has kidney problems. And
Right, that's not employment. Yeah.
But yeah, I mean, I'm just constantly busy watching her.
So how are you all able to pay for house, the utilities and everything?
Well, my boyfriend, my boyfriend pays everything for me.
Who is your
right now.
boyfriend?
Terry Jones.
And why were you driving a U-Haul with this friend?
With Terry Jones, I was not driving.
No, I mean, I'm talking
Oh,
about the other
okay,
guy, Jackson.
Well, honest, that U-Haul that we're driving, it wasn't. It was paid for by a friend of.
No. I'm asking, why were you in a U-Haul with this Jackson person if you have a boyfriend that you say pays for everything?
He was just a friend, and he was just helping me, like, we're
Helping you do what?
We're helping moving stuff
With what?
with the U-Haul.
No, I mean, why do you have a U-Haul? That's what I'm trying to understand.
How to move things around in our storage, like move from a storage to another storage, because we had to have our storage. I think out of our storage to another storage out.
I'm sorry, what?
We're moving from one storage to another storage.
Okay. Okay. All right. So this is what the court is going to do. There's $1,000 fine. That will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. You're going to have to get a job.
Okay.
Field visits 1 time per month until further notice. 200 hours of community service restitution. 100 of those hours will be deducted upon completion of a theft course. Is there any issues with you with drug use?
No.
There's to be no contact with Kenneth Ray Jackson. Probation, is there anything else? Oh, I'm sorry, 4 years deferred adjudication.
Or do you want her to report to?
Where does she live? All right, how far is New Braunfels?
It's just like 45 minutes.
And is your mother living in New Braunfels?
Yes.
All right, Miss Abrams, is it possible to get field visits in New Braunfels by that probation office? And what county is New Braunfels? Do you want your probation transferred to Comal County?
No, it'll be fine here.
All right, she does not want it transferred. All right, is there anything else, probation?
No, ma'am.
Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So here's the thing. How old are you?
I'm 32.
All right, so you're too old for this, to be doing this type of thing, and you're too old not to have employment. All right? So it's okay for you to help your mom, but helping your mom should not be you're bringing your boyfriend to live with you all. That's a no-no, because that's your mom's house, not yours. So you need to get employment so you can support yourself. You understand?
Yeah.
All right, good luck to you.
Okay.
Thank you, Judge.
Thank you.
This is heartbreaking. The defendant, Ambrosio Cabrera, is explaining his reluctance to seek treatment and work. The emotional barrier is shame, rooted in the public execution of the search warrant and his fear of coworkers finding out. The defense is trying to frame him as a highly remorseful, low-risk individual who needs supervision and treatment, not isolation in prison. This is the heart of his plea for probation versus the state's hardline opposition.
Not even treatment costs money, and it's even harder for me to even ask for a job.
Oh, that, because you know, they will see your background, is that what you know?
They will see my background from the background check, that afraid for my safety, that perhaps coworkers might find out about my charges. And I would say that if I wish that I had hope that I can have counseling to ask about things regarding getting a job. Yeah.
And you agree that you should have some counseling?
Yes.
Now, you never had an inappropriate relationship, did you?
Yes, sir.
Okay, so you just possessed images?
Yes, sir.
And have you had an adult relationship?
Yes, sir. That's
And is that still ongoing or?
no, sir.
Right now? You're willing to abide by anything the judge would require of you if she were to grant you probation?
Yes.
And you understand that you would have to register annually?
Yes, sir.
And you have anything else that you'd like the judge to know before she decides what to do?
Judge, I'm so sorry. I wish that I changed my time. I'm ready to accept the consequences.
Nothing further, Judge.
All right, any questions?
Okay, great, Judge. Mr. Cabrera, do you understand that the children in these videos are victims who are being sexually abused when the content is made?
Yes.
You understand that every time you view, download, or share those videos, that child is being re-victimized?
Good, Judge. There's no evidence of any sharing.
Sister.
Your Honor, this originates from a Nick report where it was uploaded to Snapchat, Your Honor, so.
All right, the objection will be overruled.
Okay.
All right. Any further questions? And how old are you?
22, Your Honor.
All right. All right, any argument?
Judge, Mr. Cabrera is a young man now. He was even younger a couple of years ago when this came to pass. And I think he's a person who, if you've read, I know you have read the PSI, readily admitted his responsibility, came forth and readily accepted responsibility when he was given that opportunity. He waived indictment. He came to court. He took his pleas. He showed up here today, despite knowing that he might go into custody. I think he is not a hardened criminal. He has zero criminal history other than this one case. And I don't think prison is an appropriate environment for him, and it might be actually a dangerous environment for him. So we would ask the court to consider, based on all circumstances and the lack of history, that we grant him deferred and give him whatever conditions the court finds appropriate.
Here comes. State.
Judge, while this defendant may take responsibility to enter a waiver plea on this case, that waiver plea wasn't something that he just entered, letting the court punish him to the maximum and the state charging him those things. It was a bargain between the state. We waived certain counts, we waived certain enhancements, and he entered into a plea that he thought was in the best interest of him in this case, that we all agreed was a good option. However, that plea is not for him to be agreed on probation. It's an opposed for. Now it's deferred, not probation. I should be clear on that. The content in this, we have videos of children, a video of a child under the age of 10 being sexually abused. We have images of children being sexually abused, as well as images of them nude. These children are actual victims. Just because I don't know them, just because they're not here in this courtroom, they are actual victims. This defendant
participated in their victimization by viewing, downloading, etc., this material.